Good afternoon, ladies and gentlemen, and a very warm welcome to our webinar and why you are or may be at risk when it comes to money laundering and terrorist financing. Now, the reasons for us, for our hosting the seminar or webinar now, as well as our choice of title, are in essence twofold. The first is to demonstrate to you that you yourselves or your organization itself may be at risk for the offense of money laundering. The second is to forewarn you that you may well be subject to heightened scrutiny by the Financial Intelligence Center. And what I'll do, just by way of a very brief introduction or brief overview, is just to give some content to those two reasons. That's why we thought it apposite and timeous to hold this AML webinar now. So the first, as I said, was why you yourself, your organization itself, may be found guilty or exposed to charges of money laundering. Now, while everybody understands FICA, and we've had to live with FICA for a long time now, not only as lawyers or as FSPs or as persons on whom compliance obligations are imposed, but we've all experienced the frustration of having to provide various entities with our FICA documents. So, but what one loses sight of, and it's a dangerous thing to have lost sight of, is the fact that the Financial Intelligence Center Act, or FICA as it's known, is not the only regulation or statute that you should be mindful of in running your business. It certainly is one of the pieces of legislation and one which has received the most attention. And it's highly important in that it provides the framework for the regulation of money laundering, and sets out in, or rather the framework for anti-money laundering regulation, and sets out in some detail what obligations are imposed on accountable institutions, what your reporting duty is, and the like. But as I said, it would be most dangerous to lose sight of the terrorist financing legislation itself, and then of the Prevention of Organized Crime Act. The Prevention of Organized Crime Act deals with anti-money laundering as well as with racketeering. Also provides for civil forfeiture as opposed to criminal forfeiture if goods can be found or if goods can be suspected of being the proceeds of unlawful activity. So what does this mean for you? You yourself could be found to be guilty of the main charge of money laundering if you are involved in the concealment of the proceeds of unlawful activity. That's set out in Section 4 of POCA. But where you may find yourselves even more exposed is in terms of Sections 5 and 6. Section 5 deals with assisting another person to launder the proceeds of crime, and Section 6 is even wider, in that it speaks of being in the possession or having the proceeds of unlawful activities under your control. So be mindful of the Prevention of Organized Crime Act as well as the anti-money laundering legislation in the form of FICA. One more point I want to make on the Prevention of Organized Crime Act, and in particular, the definition of the proceeds of unlawful activity, is that this is a term which is extremely widely defined. In the South African context, as is true of most jurisdictions, it comprises tax evasion. But for us, it also includes breaches of exchange control. And this is the very reason that a number of the banks are running so scared when it comes to banking crypto exchanges, crypto platforms. They are very worried that any transaction which involves the movement of Bitcoin or fiat from one platform to another will trigger exchange control regulations. And that's why a number of them have either closed crypto trading platform accounts or have been unwilling to open accounts because of this definition of proceeds of unlawful activity. And they would certainly, in receiving the monies, be found at least to be in possession or having such monies under their control. Also, we all know that statutes aren't for the most, or don't for the most, have retrospective application or extraterritorial reach. But the definition of proceeds of unlawful activities, the definition does have extraterritorial reach, in the sense that if the proceeds of unlawful activities are held offshore, and you are aware of this, or ought to have been aware of it, you could find yourself falling foul of the money laundering offense itself. Sections 4, 5, or 6 is the reporting of such suspicious or unlawful transaction. And that duty is used to be in the Prevention of Organized Crime Act. It's now been removed and is to be found in FICA. Okay, so that's the one reason we wanted to have this definition. And that is to recap, because people lose sight of the raft of legislation that you may be exposed to. Turning now to the second reason for hosting the seminar, and particularly the time for hosting this seminar, is the fact that South Africa, as is typical with other jurisdictions as well, has just been subject to a mutual evaluation by the Intergovernmental Financial Action Task Force, or FATF as it is known. And that's the supernatural, or the intergovernment task force that sets the standards in terms of its policy for anti-money laundering and terrorist financing. So each member state is subject to evaluation by the FATF. We had our evaluation fairly recently, and South Africa and accountable institutions, not all, but some, were found to be horribly wanting in their compliance with the anti-money laundering legislation. So we wanted to forewarn you that you really should take the opportunity now to make sure that you comply with the customer due diligence requirements as rigorously as you ought to, that your compliance risk and management program is up to date, because the FIC will be doing inspections. You can imagine it doesn't make the FIC look very good if the Financial Action Task Force has found the constituents or the persons over whom the FIC has supervision to be found wanting. So they will want to demonstrate that they are doing their job correctly. At the macroeconomic level, it's a very, very serious thing to be found wanting by the Financial Action Task Force. And no country, no jurisdiction will have anything to do with a country that is taken off the FATF membership roll, or that is found wanting to a material extent. So I think that's really all I want to say by way of introduction, except perhaps to say that many of us understand, and correctly, that there was an amendment to the Financial Intelligence Center Act in 2017, I think. And one of the amendments was that the rule-based approach has been substituted for a risk-based approach. But there's no legislation which is entirely risk-based. There's a continuum in most pieces of legislation, somewhere between the risk and the rule-based approach. Now, my reason for raising this here is that risk-based doesn't mean that you can determine your own risk or your risk profile entirely. There are certain prescriptions or regulation or provisions which are prescriptive and mandatory. And Era, you may be speaking more fully to this. when you do your presentation. So that then, just by way of a very broad introduction, setting out our reasons and timing for the title. So I'm going to hand over now to the other members of my team, and they will give more content, I think, particularly to the second capit, rather than to the first. What is it that you are required to do to make sure that you are compliant, not if, but when the FIC comes to be doing its audit on you? I'm going to hand over now to Lindo, and I'm going to introduce you very briefly, Lindo. Lindo is an associate in our team, and very happy to have him. And he's going to speak, if I remember correctly, Lindo, to the Financial Action Task Force, what it means, and the implications that it has for governance. So without further ado then, Lindo, let me hand over to you.
Thank you so much, Angela, for that introduction, and good afternoon, everyone. Thank you so much for joining us for this important discussion. As introduced, I'll be speaking briefly on FATF, what it is, what it covers, what its objectives are, how it is linked to South Africa. And later in my discussion, I'll be speaking about the governance issues surrounding the RMCP. Just going to share my slides. Seems like technology always has its way with me.
Not to worry, Linda. I think that picture behind you is maybe more interesting than your slides. So not to worry. It often happens that technology fails us, but
yes, I can't see.
I'm sure you'll be all right.
Yeah, I should be finding them shortly now. Okay, then let's try and share again. I guess perhaps, I think, Amelia, won't you want to go on your side and then I'll just speak after you. I do know that it does change the order of the presentation, but I can't seem to, I have my slides open, but I can't seem to be able to share them on my side. Just so that...
Let me quickly just help you there. Can you see Zoom on your side? Are you on Zoom where you can see the screen share sign?
Yes, I am on Zoom.
Click on that, share screen. Do you see your slides option there or desktop one?
No, I don't.
So what options does it give you when you say screen share?
When I see screen, whiteboard, and iPhone, and then I have...
And your PowerPoint is open currently.
Let me see this. Oh, there we go. Yeah, technology always has its way. Apologies for that. And thank you so much for your patience. I think we've been through this at some point or another. As I was saying, I'll be speaking broadly to the purpose of FACE and without wasting any additional time. So FATF is an independent intergovernmental body that develops and promotes policies to protect the global financial system against money laundering, terrorist financing, and the financing of proliferation of weapons of mass destruction. As earlier stated by my colleague, Angela, that SA is a member of FATF and has been since 2003. The objectives of FATF are to establish a strong anti-money laundering and combating of terrorist financing regulatory framework, are to enhance customer due diligence, are to ensure the adoption of a risk-based approach in the assessment of money laundering and combating of terrorist financing. Now, FATF, as earlier discussed, published a mutual evaluation report on South Africa. This was recently published on the 7th of October, 2001. In this report, as the priority item, FATF recommends that South Africa should ensure that accountable institutions adequately implement a risk-based approach, including through better assessing and understanding their inherent risk and refining and implementing their risk management and compliance programs, the so-called RMCPs, to mitigate their risks. What does this mean? In terms of the risk-based approach, accountable institutions must identify, assess, understand anti-money laundering and the combating of terrorist financing risks. The risk emanates from various factors, such as customers, countries, products, delivery channels, and accountable institutions should apply its knowledge and understanding of the risk in the development of control measures to prevent or mitigate those risks. My learned colleague will jump in later to speak more on these requirements of RMCP. Now, in terms of the RMCP, what is requested as far as governance is concerned? The board of directors, your senior management or person who is exercising the highest level of authority, has to approve the RMCP and has to ensure its compliance with FICA and the institution's compliance with FICA and the RMCP. Your board of directors also must create a culture of compliance, ensuring institutions' policies, procedures, and processes limit and control risk of money laundering and terrorist financing. Furthermore, your board of directors or senior management should be fully engaged in the decision-making processes and take ownership of risk-based measures adopted. And finally, and not least, your institution must have a compliance function to assist the board of directors or the senior management discharging the obligations and assign a person with sufficient competence to ensure the effectiveness of the compliance function. Now, in terms of the RMCP, what must be included in it? What must it cover? It should cover training on money laundering and terrorist financing. It should cover appropriate provision of regular and timely anti-money laundering and combating of terrorist financing information to the board of directors and senior management. It should cover documentation of risk management policies and risk profile, including documentation of their application, CDD decision-making processes, and other risk management measures, measures to ensure that money laundering risks are taken into account day to day, including in relation to the development of new products, taking on new clients, and the changes in business profile. Accountable institutions, RMCP, must be commensurate with the size of the institution and the nature of its business. The nature and the extent of the accountable institution's internal systems, controls forming part of its RMCP, depending on various factors. Some of these would be including the nature, the scale, and the complexity of business, the diversity of its operation, including geographical diversity, the client, product, and service profile, distribution channels, volumes, and size of transaction, the degree of risk associated with each area of operations, and the like. Now, on the very fundamental and important aspect of the RMCP is, of course, as you'd be interested to know, is what happens in the case of non-compliance. And FICA is clear that the board of directors or senior management that both fail to ensure compliance are non-compliant and will be subject to administration sanctions. Now, FICA and SAB may impose any one of the following administrative sanctions. It can either impose a caution, simply not to repeat the conduct, or a reprimand, or a directive to take remedial action and to make specific arrangements, or a restriction or suspension of certain specified business activities of an accountable institution, or a financial penalty not exceeding 10 million. This can either be imposed on a natural person or on a legal person. In case of a legal person, it's an amount not exceeding 50 million rand. Now, Section 45 of FICA further provides that that FICA may impose also that a financial penalty must be paid by a natural person or person for whose action the relevant institution is accountable in law. So what this basically means is that directors themselves of the company may be independently held liable depending on the non-compliance of an accountable institution. And on this note, I will hand over to my learned colleague, Amelia Warren, who is our candidate legal practitioner. Wonderful to have her and to work with her to continue from this stage with the requirements of the RMCP.
Thank you, Lindor, for that introduction. So as Lindor mentioned, I'm going to be dealing with the requirements of the risk management and compliance program, which is essentially set out in section 42.1 of FICA, which says that all accountable institutions must develop, document, maintain, and implement a program for anti-money laundering and counter-terrorist financing risk management and compliance. And then section 42.2 of FICA goes on to set out the specific requirements that must be included in a risk management compliance program or an RMCP. There are 19 different requirements. It's quite an onerous section. So I am going to touch on each briefly, but I do ask you to bear with me. Okay, so the first two requirements for the risk management and compliance program are firstly that the program must enable an accountable institution to identify, assess, monitor, mitigate, and manage risk. So already off the bat, it's clear that the RMCP aligns with the risk-based approach and has to be designed to allow institutions to cater for and mitigate risk. The second requirement is the RMCP has to provide for how the accountable institution will determine whether prospective and current clients are in the process of entering into or have entered into either a business relationship or a single transaction. So a business relationship is essentially a relationship concluded for the purposes of concluding transactions on a regular basis with the accountable institution, whereas a single transaction is included outside the realm of a business relationship. This is an important distinction because quite a few of the requirements contained in the RMCP, which we will see, cater specifically to business relationships, but not single transactions, because accountable institutions will have much more information about clients with whom they establish business relationships. Okay, the next three requirements. Firstly, the RMCP has to provide for Section 20A of FICA. Section 20A essentially says that you can't conclude transactions with anonymous clients or with clients with false or fictitious names. So you specifically have to include that in your RMCP. Furthermore, you have to provide for the establishment and verification of identity of certain persons as set out in Part 1 of Chapter 3. And you have to provide for the manner of determining whether transactions are consistent with the accountable institution's knowledge of the client. So that would be an example of a requirement that would apply to a business relationship, and it is specified in the subsection that applies to a business relationship, but would not apply to a single transaction. Okay, the next two requirements, the RMCP has to provide for additional due diligence in terms of certain legal structures, so legal trusts, legal persons, and partnerships. That's important because these types of structures can sometimes be quite complex, and therefore they can lend themselves to an increased risk for money laundering and terrorist financing. So the RMCP has to cater for that to counter that added risk. Then they also have to provide for ongoing due diligence and monitoring. And once again, this requirement specifies that applies to business relationships. Then the RMCP has to provide for the examination of complex or unusually large transactions, and also unusual patterns of transactions that don't seem like they have a lawful or business purpose. So transactions that may raise suspicion in that way. The section also provides that in addition to examining those transactions, the RMCP has to say that you provide written findings in relation to those transactions. Furthermore, the RMCP must provide for the way that the accountable institution confirms client information where it doubts the veracity of previously obtained information. So where you are given information by a client that seems suspicious, the RMCP has to cater for how you will verify that information. The next three requirements, you have to provide for customer due diligence, which I think Ira will deal with extensively in her presentation. But you specifically have to provide for customer due diligence when the accountable institution suspects that a transaction is suspicious or unusual, and that references section 29 of FICA. You also have to provide for the way that the accountable institution will terminate an existing business relationship in terms of section 21E, and provide for the way that the accountable institution determines whether a prospective client is a foreign prominent public official or a domestic prominent influential person. And that's important because these types of clients would also have a higher risk level in terms of money laundering and terrorist financing. So it's important to be able to distinguish them. The RMCP must also provide for enhanced due diligence where there are higher risk business relationships, must also provide for when simplified due diligence is permitted. So again, that's catering towards the risk-based approach. It must provide for the manner and place for keeping records and for the determination of reportable activities in terms of part 3 of chapter 3. The RMCP must provide for the process of reporting information to the Financial Intelligence Center, and it must also provide for instances where your company has branches or subsidiaries or other operations in foreign countries. And in those instances, you have to determine whether the host country of a foreign branch would permit the implementation of measures under FICA. And if it doesn't permit the implementation of measures under FICA, how you will inform the FIC of that fact. Then the last two requirements, the RMCP must provide for the processes for the accountable institution to implement its program and for any other prescribed matter. Just one final point, Lyndall did mention that the board of directors or senior management, a person with a high level of authority may approve the RMCP, and section 2C of section 42 also says that the RMCP must be reviewed at regular intervals. But another important element is section 2A says that if none of the paragraphs under section 42.2 are applicable, you still have to say in your RMCP that they're not applicable and explain why. So you can't just completely ignore that requirement. So for example, if you don't have a branch in a foreign country, you can't just ignore that requirement of section 42.2. You have to say that you don't have a branch in a foreign country and therefore explain why it's not applicable. Those are all the requirements of the RMCP. I'm now going to hand over to my colleague, Ira Gunning.
Thank you so much, Amelia. And Linda, I just wanted to add that the technology curse on our team used to be on me, but it seems like since you joined our team, it's moved over to you. And I must say, I'm quite relieved to see that it's shifted. So hopefully you can all see my slides. And I'm delighted to be talking to you about the main requirements in terms of our anti-money laundering law, FICA. So, of course, as Amelia said, that RMCP is incredibly important for any accountable institution. It's crucial that you do cover, as Amelia said, absolutely every single point in that RMCP. Because what the FIC does is, during COVID, they started doing desktop inspections. So they may ask you for a copy of your RMCP, and they literally use Section 42 as a checklist to make sure that you have covered each and every single item. So, of course, in terms of FICA, accountable institutions and other businesses, and I'll draw the distinction soon, have many obligations. You must have an RMCP, you must appoint a money laundering control officer, you must do training. But the three that I'm going to focus on today is your customer due diligence, your record keeping, and your reporting. As far as your customer due diligence is concerned, Angela also touched on the following. Angela made it clear that there isn't a statute that is completely and entirely risk-based. And we found that a lot of our clients thought, as far as customer due diligence is concerned, you can nitpick what you want to do and what you don't want to do. That certainly is not the case. When it comes to identification, there are rules that you have to follow, but when it comes to verification, you can set your own rules as how you're going to do the verification based on the risk posed by the customer. So we're going to look at customer due diligence, we're going to look at record keeping, and we are going to look at reporting. And thereafter, I'm going to hand back to Amelia to tell you about an interesting recent court case on customer due diligence. But as far as customer due diligence is concerned, it comprises various elements. First of all, you've got the CIV, the customer identification verification. So that is an aspect of knowing your client, checking that their identity, they are who they say they are. Then there's ongoing customer due diligence. So you have to make sure that if a customer's details were to change, if their risk profile were to change, that you update the status of that customer. And then we have to do enhanced due diligence for high-risk clients, such as politically exposed persons. Now, the starting point is to check whether you are an accountable institution. So we've been mentioning the term accountable institution. Accountable institutions are defined in Schedule 1 to FICA. They include the likes of banks, financial services providers, long-term insurers, accountants. They include attorneys, estate agents, and so on. There are also a number of businesses on the radar of the Financial Intelligence Center, and they are soon going to become accountable institutions. And these are our crypto asset service providers, I always forget that term, also our short-term insurance and our credit providers. They are soon going to become accountable institutions. We also have reporting institutions. Reporting institutions are Kruger-Rand dealers and motor vehicle dealers. They are also going to move up to accountable institution level soon. So we've got accountable institutions, and they must comply with the whole of FICA. And then we have businesses who do business in South Africa, or companies or persons who do business in South Africa, and they only have to comply with the Section 29 requirements saying that you have to report suspicious and unusual activities. So any person doing business in South Africa must report these unusual transactions, not only accountable institutions. More on that later, but we are going to focus now on the duties of our accountable institutions. Now, first of all, when we talk about customer due diligence, it's important to note that our customer due diligence must only, in terms of FICA, be performed on clients. And a client is a person with whom the accountable institution enters into a business relationship or a single transaction. Very often we've got clients asking us, must we perform a customer due diligence or CDD on our employees? Must we perform a CDD on our business partners and on our suppliers? That is not a FICA requirement. Maybe a requirement in terms of other laws, but it is not a requirement in terms of FICA. FICA is focusing on your client due diligence. I'm not going to talk too much about single transaction and business relationship because that has been covered by Amelia. Safe to just reiterate that you must do more in respect of clients with whom you enter into a business relationship as opposed to clients with whom you enter into a single transaction. Very important in your environment to customize your RMCP, to set out in your environment what will be seen as a single transaction, what will be seen as a business relationship. The terms are quite vaguely defined in the Act, and it's a requirement, and this is often flagged by the FIC in the inspections if you did not set out how it pertains in your environment. Now, Section 28 to 20A, as Amelia also mentioned, said you cannot enter into a business relationship or conclude a single transaction with a person who has a false or fictitious name. So don't do business with Mickey Mouse. So if you, with anybody that you do business, you need to get their name. So what's quite interesting, Section 20A is the only section that deals with due diligence that doesn't have a threshold. So a single transaction is defined as a transaction above 5,000 Rand. But when it comes to Section 20A, it applies to all transactions, regardless of the fact that it may be a transaction under 5,000 Rand. For the rest of the CDD requirements that I'm going to discuss now, it would only apply if you are entering into a business relationship or single transaction above 5,000 Rand. Now, the often quoted section, Section 21, this is where we start with our due diligence process. Section 21 says, in the course of entering into a single transaction or establishing a business relationship, you must do certain things. Now, it's quite interesting. Before FICA was amended about 5 years ago, this section had read that you must do this part of the CDD before entering into a business relationship or entering into that single transaction. It now says in the course of, whatever that means. So you have to establish and verify the identity of the client. And if somebody is acting on behalf of the client, you must establish the identity of that person and the authority to do so, and vice versa. So if another person is acting on behalf of the client, you must also do the same. So that is where we start our due diligence process. Then we move on to Section 21A. And this is now where you have to do more if you are dealing with a business relationship. So if it was a single transaction, your journey would not move on to Section 21A. Now, Section 21A says you must find out more about this business relationship so that you can understand whether future transactions with this legal entity or with this human being is in keeping with what you know about your customer. So this is the KYC aspect. You need to know your customer so that you know that future transactions align. So you'll be looking into the nature of the business relationship concerned, the intended purpose, why did they come to you, and the source of funds, where do they get their money? Is it a salary? Where are they getting their money from? What is interesting here is that this section says you need to find information describing. It doesn't say you have to verify the information. So here you ask the customer about the nature of their business relationship and their source of funds and so on. When you are dealing with a legal person or partnership or trust, you now have more homework to do. And in terms of Section 21B, you need to look at the nature of the client's business. Sounds a bit like the previous slide. The previous slide was dealing with a business relationship. Now we're looking at the nature of the client's business. What do they do? And we have to look at the ownership and control structure of our client. One of the most difficult sections in FICA's 21B. And 21B says, if you are dealing with a legal person, in accordance with your risk management and compliance program, you have to establish the identity of the beneficial owner of the client. Who is a beneficial owner? In layman's term, it's that warm body that pockets the money at the end. Who is the person who really benefits from the activities of this legal person? Now, FICA describes 3 steps that we have to follow. First of all, to establish a beneficial owner, we have to look at who's got the controlling ownership interest. Usually we're looking at 25% or more of the shares with voting rights. And quite interestingly, the court case Amelia is going to speak to just now also spoke about this 25% thing, but that used to be a requirement in terms of Regulation 7, which has been repealed. So we're looking at 25% or more of the shares with voting rights. If we can't find that person, we move on to step 2. And we look at a person who exercises control through other means, such as voting power. Still haven't found our person, we move on to step 3. And step 3 says, now we look at a person who exercises control over management, such as the directors, executive or non-executive directors. Very difficult in practice to find your beneficial owner, and you also have to verify your beneficial owner. In other countries, for example, in Europe, there are beneficial ownership registers that make it much easier. Eventually in South Africa, we are also going to have a beneficial ownership register, and that would make our lives easier. When you deal with a partnership, specific requirements, you have to look at the name of the partnership, every partner, silent or managing, and the managing partners, the managing partners as well. So the ones who exercise executive control. So not only must we identify who those persons are, we also have to verify their identities. So that means we must check that they are who they say they are. And as we've been speaking about the rule versus risk-based approach, of course, the verification that you are going to apply to these human beings would depend on the risk of money laundering that they pose. When it comes to trusts, we have to look at the name and trust number, the master's office where it was registered, the founder of the trust, each trustee and person appointed to act for the trust, and each beneficiary, if the beneficiary is, of course, named in the trust. And on top of identifying these persons, we also then have to verify the natural persons. Again, stricter verification would apply when we are dealing with high-risk clients. You have to conduct ongoing CDD. So once you're finally done with this whole process of establishing and verifying who you are dealing with, the second part of CDD kicks in, and that is ongoing CDD, where we now have to monitor transactions. And if it is necessary, we have to look at more deeply into the source of funds, and we have to look into the background and purpose of complex and unusual transactions. So this is where, again, the KYC comes in, knowing your client, checking what they're doing fits in with what they told you they will be doing. If it is a person who told you that their source of funds would be a salary of 10,000 Rand a month, and all of a sudden they start banking 50,000 Rand cash a day, you're probably dealing with somebody who is up to no good. So these are the sort of things that would then trigger a suspicious transaction report. And then you've now obtained all this information, you're doing your ongoing due diligence, you still have to do more, you have to keep this information up to date. Generally, you would check that information is up to date, also linked to the risk posed. So for example, if you're dealing with high risk clients, you may want to check that the information is up to date yearly. If you're dealing with medium risk clients, every second year. Low risk clients, maybe every 3 years. FICA doesn't say how often we must do it, but that must also be set out in our RMCP. And of course, this is also a requirement in terms of Condition 5 of the Protection of Personal Information Act, POPI. As Amelia said, if you now start doubting the veracity of your information, if you think something is a bit fishy regarding the information that they've provided to you, including something such as source of funds, then you need to repeat the CDD steps that are necessary to repeat until you feel comfortable that you know your client. If you can't conduct your CDD, either you cannot obtain the information that you need, then FICA is quite clear about that. And also it's not only if you cannot establish the business relationship, it's also if you can't conduct your ongoing due diligence. then you may not establish a business relationship. You cannot conclude any extra transactions if you have already established the business relationship, or you must terminate this business relationship as set out in your RMCP. So again, that RMCP, incredibly important, because it must also tell you how are you going to terminate this business relationship. As an aside, also make sure that your terms and conditions speak to the termination of a business relationship. Then we get our politically exposed persons overseas. They call these people PEPs. We've got a fancier term or fancier terms in terms of FICA set out in Schedules 3A and 3B. And we've got a domestic prominent influential person and a foreign prominent public official. These are our PEPs as set out in those schedules to FICA. And we also have to treat their family members and known close associates as high risk. And of course, we need to set this out how we do this in our RMCP. Now, as a general rule for PEPs, we have to obtain senior management approval to deal with them. We need to look at their source of wealth and source of funds, and we have to do enhanced ongoing monitoring on them. So very important that our RMCP sets out exactly what, in addition to our low-risk clients, what in addition will we do when it comes to our politically exposed persons. So we've dealt with TDD. The next main duty that we have is our record keeping. So very important, we've done all this work now. We need to be able to show that we've done all the work. And of course, if the FIC wants to investigate and they want to find this person, we need to have records available to give the FIC the information that they need. Very interesting, and this is another change that was made in the FICA Amendment Act, is it says we can keep copies of or references to the information that we obtained in our CDD process. So we don't necessarily have to keep copies. We've got this option of rather keeping references. And some would argue that we should not be keeping copies of a person's identity document for data protection issues. If there's a breach and your identity documents are compromised, that could have enormous consequences, identity theft and so on. So you want to keep a reference of the fact that you have cited that identity book or identity document, and that you have verified that it is the person is who he says he is, but you don't necessarily have to keep copies. FICA speaks of keeping your records for a period of 5 years, either from entering into the transaction, or terminating the business relationship, or reporting, filing a report. But what is very important, and that we also see a lot of our clients have missed, is that this must be read with Section 24 of the Companies Act. Now, Section 24 of the Companies Act says, if you keep records in terms of the Companies Act or any public regulation, which is very widely defined to include any other law, such as FICA, then your default should be 7 years, unless that other law says longer. So if you've been keeping your records only for 5 years in terms of FICA, please note it should be 7 years if you read it with the Companies Act. And then finally, what I'm going to cover in terms of duties in terms of FICA would be your reporting duties. The 3 main ones would first of all be to report cash transactions, and this is cash in or cash out above 224,999, so 25,000 or more. If you receive that money in cash, hard cash, notes, coins, then you need to report it to the FIC. And by the way, it's not only our accountable institutions that must report these transactions, it is also our reporting institutions, our Krugerrand dealers and our motor vehicle dealers who must report these transactions to the FIC. And when the FIC does an inspection, they actually go through your bank statements and they check whether you have missed any cash transactions, that cash that were deposited into your bank account. Terrorist property reports. So in terms of Section 28A, if you find that you've got in your possession property belonging to a terrorist, you need to file a terrorist property report. In a similar vein, a section that kicked in a little bit later than Section 28A is 26A, and it says that if you find that a person is subject to targeted financial sanctions, you must also file a report in this regard with a FIC. So to determine whether you have to file a report in terms of 28A or 26A, you need to do regular sanction screening. Interestingly enough, FICA also only imposes this requirement in respect of a business relationship, not in respect of a single transaction. But if you missed a person and you have terrorist property in your possession, you would file off Section 4 of POCTATARO, which is our terrorist property, the terrorist act which Angela mentioned. So sanction screening must be done against the UN sanctions list and against the targeted financial sanctions list. Our last report that we have to file currently is our Section 29 report, and this deals with unusual transactions or unusual activities where you have a suspicion. Whereas with 28A, the previous slide, our terrorist property reporting requirements, we must have actual knowledge. Here, a suspicion would suffice. So if you suspect that somebody is up to no good, you must file these reports. And if you file a Section 29 report, it is also a defense against money laundering. So basically, if there's doubt, there is no doubt as to file one. There are also going to be reports to be filed for international fund transfers. So overseas, we refer to them as wire transfers, but that Section 31 is not in force yet. The last thing I just want to touch on is our fintech developments. We've seen quite a lot of fintech apps on the market, identification and verification apps. Things to bear in mind here is sometimes these apps use biometrics, fingerprints, voice, video, facial recognition. Bear in mind, this is biometric information in terms of a POPI, which is special personal information, get consent to do so. A validation versus verification on ID numbers. What is the difference? Validation checks that it is a valid number. It meets the requirements of a valid ID number. Verification checks that it is actually linked to a specific person. Check whether your apps authenticate documents or not. Check where data is housed and if they can use the data for other purposes, because of course then we need to take into consideration POPI. And at this point, I'm going to hand back to you, Amelia, to tell us about a recent case.
Thank you, Ira. Let me just share my screen. Right, so this is a very recent decision. It was handed down on the 19th of May this year, and it's an SCA decision in the case of Nedbank v. Houtbos-Plus. The facts of the case, very briefly, is that two companies, Houtbos-Plus and TBS Alpha, sued Nedbank for damages for failing to give immediate effect to their instructions to close their accounts with Nedbank and transfer all their funds to a bank account at ABSA. What happened was Nedbank had requested copies of trust deeds of 4 trusts on the basis that each of the 4 trusts held 25% of the issued shares in the 2 companies. So this links to what Ira was speaking about regarding beneficial ownership. And it is worth pointing out here that the facts of the case took place before 2017. So the court was interpreting provisions that are slightly different to the provisions that we are faced with now. And this was before the Amendment Act and the risk-based approach, and before Regulation 7 was repealed. The 2 companies, in response to the request from Nedbank, refused to provide the deed for one of the trusts on the basis that it was an invasion of privacy, and essentially just requested Nedbank to close their bank accounts and transfer the funds. Nedbank refused, and it relied on Section 21 of FICA and Regulation 7 in doing so. So the 2 main legal questions that were considered in the SCA case was firstly whether Nedbank could rely on the provisions of Section 21.2 of FICA and Regulation 7, even though it had already established business relationships with the companies. And secondly, whether the trusts did in fact have 25% of the issued shares and 25% of the voting rights. So on the first question, the court interpreted the meaning of section 21(2), which just briefly says that if an accountable institution has established a business relationship with a client before FICA took effect, the accountable institution can't conclude a transaction with that client until it has taken steps to verify the identity of that client in terms of FICA. So that was the provision that Nedbank was relying on to try to say that it couldn't conclude any transactions, including closing the bank account, before it had verified these 4 trusts. The court essentially found that Nedbank couldn't rely on section 21(2) because it had already established a business relationship with the companies in accordance with FICA once FICA had come into effect. So it had a business relationship with these companies before FICA, and then once FICA came into effect, there was no evidence that Nedbank presented which suggested that they weren't FICA compliant for the transactions that they concluded with these companies following the introduction of FICA. So what the court said is because it had already concluded this business relationship, which was FICA compliant, Nedbank could not rely on this provision to require identification and verification for each and every transaction once that business relationship had already been established. So that's just quite an interesting interpretation of the provisions. And then secondly, on this other issue, a lot of the discussion there wasn't really relevant for our purposes because it related to the memorandum of incorporation of the companies. But I do think what was interesting is the way that the court dealt with the argument proposed by Nedbank that the memorandum of incorporation of the companies should be interpreted expansively given the laudable purposes of FICA. So given the purposes to prevent money laundering and terrorist financing, the court should be slightly more lenient in its interpretation of the memorandum of incorporation. The court essentially rejected that argument and said that the purposes of FICA could not be used to change the ordinary meaning of the memorandum of incorporation. So those were the 2 main issues that we just briefly wanted to alert you to. I'm now going to hand back to Angela to conclude for us.
Hello, sorry. Yes, I think very, very much to the attendees and to the speakers. I thought the presentations were of a very high standard, and thanks to my wonderful team members. Just want to make one point, if I may, Ira, and it's more to show that I was listening than anything else. When you speak about suspicious transaction reporting, you're quite right in saying that the test is a lower one than knowledge in that it requires suspicion, or suspicion is enough to trigger the reporting duty. I just want to make one point that it is suspicion, but it wouldn't be enough to say I didn't suspect, because that duty is overlaid by how a reasonable person in the position of that person confronted with the suspicion would have reacted. So it's both subjective, but that subjective suspicion should be tested against the reasonable person in that person's position with the reporter would-be reporter's knowledge super added. But I'm afraid we have a hard stop now. And thanks again. And if anybody does have questions, you can direct them to us and we'll do our very best to provide you with answers. But as I say, returning to the purpose, please guys, just make sure that your customer due diligence is properly compliant will you comply fully with your CDD requirements, and even more importantly, your RMCP. As Zira correctly pointed out, the FIC does use this as its checklist. So on that note, thanks again to attendees and to panelists.